what we know Ellis is dragging these guys across the street. There's no video of these moments, right? Because there's been that exhibit shown to you where we know that they have Vivint, then we have McDowell, we have Lowry, and then we have more Vivint video, and then there's one Vivint clip that shows Officer Rankine arriving, and then there's nothing, and then there's the white video, and then there's nothing until you see a bunch of emergency vehicles there through Vivint. I think that's exhibit 443 is the full synced video. And then you see again a white video, and it's Officer Rankine trying to resuscitate and help with fire there, right? And so in this analysis, as it appeared to him, what is the amount of force? It's a low level of force. That's not an amount of force that is substantially likely to cause death, right? That is a bizarre proposition, especially when you put the individual in the recovery position twice. If it was substantially likely to cause death, Ford and those other officers would have said something. They all would have said something, said, hey, rookie, don't do that, right? And that's because it's a low level of force, and it's reasonably effective for the lawful purpose that he's trying to do, which is keep Ellis detained in that moment and figure out what's going on. Fire gets called within a minute. We know fire's coming. They're waiting around. It takes longer because we're at the outskirts of the city. And we know that Ellis is in the recovery position and those other aspects of it. The state takes issue with the other use of force that he uses. I guess you can call it a use of force. But it's when Ellis starts thrashing around when he's in hobbles, right? And he starts thrashing around. He's on his shoulder. And, practice going on your shoulder and thrashing around. And, he really has to use force to keep him steady in that. So he's either holding, and I think Chris Nielsen discussed this pretty well. He's like, well, he's either going to hold him down there. That's force. He has to hold him in place. But Rankine was driving how he's like teetering, and so he's falling to his belly as well, or his stomach. And that the amount of force that he's using in that scenario is not significant because he doesn't need to use significant force because he's hobbled. And if he would have, someone, Ford, who's sitting right there with him, would have said something. And I think that if you look at this scenario as to what Officer Rankine did, you'll find that at the time as it appeared to him, it was reasonable for him to use force, and that the amount of force was reasonable to affect the purpose he had in that moment, which was to keep control of Mr. Ellis. The last thing I want to talk to you about is beyond a reasonable doubt. So this instruction is the cornerstone of our judicial system. Beyond a reasonable doubt. The defense has no burden of proving anything. We don't have to prove that a reasonable doubt exists. They're presumed innocent. Each officer sitting there is presumed innocent. So the allegation against them is just that. It's an allegation against them. And that presumption continues throughout the trial unless you deliberate and you find that it's been overcome by the evidence beyond a reasonable doubt. And that means a reason, right? A reasonable doubt is one for which a reason exists. It may arise from the evidence or the lack of evidence as well. I think that if you look at this scenario as to what Officer Rankine did, you'll find that at the time as it appeared to him, it was reasonable for him to use force, and that the amount of force was reasonable to affect the purpose he had in that moment, which was to keep control of Mr. Ellis. The last thing I want to talk to you about is beyond a reasonable doubt. So this instruction is the cornerstone of our judicial system. Beyond a reasonable doubt. The defense has no burden of proving anything. We don't have to prove that a reasonable doubt exists. They're presumed innocent. Each officer sitting there is presumed innocent. So the allegation against them is just that. It's an allegation against them. And that presumption continues throughout the trial unless you deliberate and you find that it's been overcome by the evidence beyond a reasonable doubt. And that means a reason, right? A reasonable doubt is one for which a reason exists. It may arise from the evidence or the lack of evidence as well. If you take the evidence in this case and you apply it to the law, no outside influence, that doesn't apply. That's why we selected all you through this process for 3 months. And if you do that, and you look at Officer Rankine's actions, his evidence of care, of working with his partner, Officer Ford, in this moment, in a difficult moment, and you saw his emotion in there as well. And if you apply the facts, the actual facts that have been proven in this case, and I would say the defense has proven more facts than the state has in this matter. If you apply those facts to the law, there's only one result in this case, and that's a not guilty verdict for Officer Rankine. Because to say that he took actions that would create the substantial likelihood of death, that is a gross deviation from the conduct a reasonable person would exhibit, that he failed to do that he knowingly disregarded that, right? Or that he's the cause of death in this case. That's not what the facts show us. It shows care, right? When Lieutenant Wilson was on the stand, there was something that he talked about, which I thought was significant, right? He's not a paid expert. He doesn't know any of these guys. He said that the officers helped more than he ever would have expected. And that, remember the first reaction that Officer Rankine had when he got there? He said, "What can I do to help?" Wilson said that he wanted him out of the restraints. The first person he went to was Sergeant Lynn to ask for permission. But in that scenario, he wanted to help. He cared. And I ask that you don't compound one tragedy with another by not holding the state to their burden, by not applying the law to the facts in this case in a way that is demanded for justice. And if you do that, again, I think that the result is clear. No doubt. It's not guilty in this case. Because reasonable doubt is plastered throughout this matter. They've not set forth one single eyewitness against our client that has said anything about him negative other than a paid expert.